Hi, Amy.
Hi, do you mean to record this part?
Yeah, it's because of the number of attendees, there's no kind of practice, so maybe go off video and we'll connect when we have enough people.
What I mean is you might want to stop the recording.
Good afternoon, good morning, good evening, everyone, depending on where you're joining us from. My name is Myriam Seers. I'm an international arbitration partner at Savoie La Porte, and I'm absolutely delighted to be hosting this panel today, entitled, Is There an App for That? Arbitration of Smaller Commercial Disputes in the Technology Sector, as part of the first day of Paris Arbitration Week. This is the first of two panels that Savoie La Porte is presenting during Paris Arbitration Week. The second is tomorrow, September 21st, also at 5 p.m. Paris time, which will be moderated by my partner, Pierre-Olivier Laporte, and is entitled International Organizations as Users and Providers of International Arbitration. So if you're not already registered for that, we hope that you can join us for that panel too. Today's topic about arbitration of technology disputes is timely as the world begins to reopen. I'm fortunate enough to be here in Paris this week for Paris Arbitration Week. It was my first time traveling in 22 months. So it's great that that is starting to happen again. And so in that context, we ask ourselves, what have we learned during the pandemic about how to conduct arbitral proceedings better? What will arbitration look like in the short, medium, and long term, and how do we get there? Which of course are questions, the answers to which apply to all types of disputes beyond just technology disputes. And we have a first-rate panel of thought leaders in the area of technology and dispute resolution to help us explore the answers to those questions today. So first, I'd like to welcome Sophie Nappert, who is an independent arbitrator based at 3 Verulam buildings in London and is dual qualified in Canada and the UK. Before that, she was the head of international arbitration at a global law firm based in London. She's ranked as most highly regarded and a leading light in international arbitration by Who's Who Legal. Sophie writes and speaks extensively on the use of technology in international arbitration. She's completed the University of Oxford's Said Business School program on blockchain strategy. Earlier this year, she co-founded ArbTech, which is a worldwide online community forum that fosters cross-disciplinary dialogue on technology, dispute resolution, and the future of justice. And you can find it on LinkedIn as ArbTech or on Twitter at ArbTech_hub. Professor Amy Schmitz is the Elmwood L. Thomas, Missouri Endowed Professor of Law at the Center for the Study of Dispute Resolution at the University of Missouri, Columbia. She publishes and speaks widely in the areas of online dispute resolution, artificial intelligence, blockchain, smart contracts, and the intersection of those topics with arbitration and litigation. She's a fellow at the National Center for Technology and Dispute Resolution, as well as the co-chair of the Technology Committee of the Dispute Resolution section of the American Bar Association and its Online Dispute Resolution Task Force. She's also a researcher with the Cyber Justice Laboratory, with which she is researching artificial intelligence and online dispute resolution. And she's also the host of a web series on arbitration called The Arbitration Conversations, which you can find on YouTube. And last but certainly not least, Colin is a developer of online dispute resolution platforms, joining us from Silicon Valley, San Jose, California, where it is 8 a.m. So thank you so much, Colin, for joining us so early. The epicenter of the tech industry, as you all know. He's currently the CEO of arbitrate.com and mediate.com. He's the former director of online dispute resolution at eBay and PayPal, where he designed dispute resolution systems that led to the resolution of, I won't even guess how many claims, a very large number of claims every year. He's also co-founder of Modria, which is an online dispute resolution service provider, and he writes and speaks widely on arbitration and technology issues. He's been called the, quote, godfather of online dispute resolution, which is not at all surprising given his resume, but also given the fact that his first book, Online Dispute Resolution for Business, was published in 2002, at a time when there was certainly no Zoom and the iPhone was still about 5 years into the future. So I would encourage all of you, although we have quite a large number of attendees, if you have any questions during the panel, please feel free to pose them in the Q&A. I'll try to, I'll do my best to integrate them as we run through the panel at the appropriate time. And also speakers, feel free to answer the questions in writing during the Q&A function if you can when you're not speaking. Just want to make sure that we are recording. So perfect. Anyone who was not able to attend today can get the recording. So I'd like to begin this panel about technology disputes by talking about disruption, or the tech sector notion of disruption, which is that you identify a segment of the market, you find a way to do it better, and you turn an entire industry on its head that previously couldn't imagine what was about to happen to it. To quote a certain big tech CEO, technology, quote, moves fast and breaks things. So Sophie, why don't I turn it over to you first? Do you think that arbitration is going to be disrupted the way other industries have been?
It is, is the answer to that question. And it's begging to be disrupted. It is classically a target for disruption, and it doesn't seem to be realizing it. And especially our theme today is smaller disputes. I don't think that arbitration, as we practice it, is about to be disrupted when we talk about the multi-million-dollar or even the smaller dispute, but with state entities or multi-party disputes, for example. These are, I mean, they will be if they carry on the way that we are, but this is not what we are talking about. It's the more sort of the simpler, more binary, pay the claimant, don't pay the claimant. Is there a breach? Is there not a breach? These types of disputes are absolutely being disrupted. And particularly, two things maybe I can say to that before giving the floor to my co-panelists is, the fact that e-commerce is an immense area where disputes are arising, as Colin knows very well, instantaneously, and they need an instantaneous resolution. They're small amounts of money, but they matter to the people, obviously, who transact. We all live online now, we transact online. Disputes are bound to happen online. And what does arbitration have to offer? Time and costs that we keep complaining about, but we don't seem to be doing much about for reducing, and certainly nothing instantaneous, because our notion of due process as it exists is a time-heavy notion. It's a time-reliant notion. Our notion of gathering evidence is time-reliant. I mean, I hope I can come back to that a little bit later, but that to me is crucial. And it's a crucial area that the disruptors that we're going to talk about are targeting, and they are right to do so.
And many of the people tuning in are either arbitration lawyers or arbitrators. What do you say to them? What does disruption in the way that you're describing it mean to the people joining us today?
Is it still me?
Well, whoever would like to answer that question, you're welcome to. So
maybe I'll let somebody.
You're the arbitrator on the panel.
Well,
what does it mean for you?
What I say to them, what I've been saying to them, and the thing that really animates me now is that I think that for these types of dispute, we, the stakeholders of arbitration and those who are versed in it, need to rethink the notion of due process that I just talked about. I mean, it is important. Due process is crucial. It's a foundational to what we do. But the fact that it takes forever is starting to play against us and it's not serving the users, and certainly not serving e-commerce. So that's what I would say.
Absolutely. And Amy, Colin, would you anything to add about that?
Sure, I'd pitch in on that. I think Sophie got it exactly right. If you actually read Clayton Christensen, the Harvard Business School professor that really is the father of disruption, what he talks about is, there are certain services that are high value, but they're incredibly complicated and they're incredibly expensive, and they're only available to a relatively narrow band of the population. And disruption happens when someone comes in and figures out how to deliver that same service in a much simpler way, in a much faster way, in a much cheaper way, and it expands access in a radical in a radical manner. And I think that when you think about the roots of Lex Mercatoria and the international arbitration system, it really was for big companies. Those were the only entities that were transacting cross-border for, for many, many decades. But what the internet has done is any of us can pull out our phone and swipe, swipe, swipe. We can make purchases on the other side of the world. And that's true for small and medium-sized businesses now. And I think what's happening is they need access to these services as well. And the way that they've traditionally been provided by the arbitral institutions, it's too complicated, it's too costly, and as Sophie says, it's too time consuming. So now there's a new demand. There's an opportunity for us to build a faster, more nimble, more streamlined process that better meets the needs of these other stakeholders. And I think Sophie is absolutely right. Incumbent players ignore these dynamics at their peril. This has happened in every other industry. If you say, well, I'm not going to pay attention to these dynamics, I'm just going to keep doing things the way that I'm doing them, well, someone else emerges that provides that service in a manner that is more easily consumed by these new constituents. And that's when the disruption happens, because everybody switches from one provider to another. Now, I think none of us want to necessarily see that. We're not rooting for the demise of the legacy arbitral institutions. We want to help them change. We want to help arbitration evolve. That's one of the beauties of arbitration, is it is nimble enough to evolve, unlike the judicial system with changing market dynamics. But I think if that change does not happen fast enough, there is a risk of a truly disruptive change. And I think all of us know that there are new players, and maybe we can speak to some of them, who are thinking about radical ways of redesigning evaluative dispute resolution systems, cross-border, cross-jurisdictional dispute resolution systems. And if the incumbent players don't move fast enough, I think some of those new entrants will gain more of a foothold. That's my sense.
I mean, at least
and
one
I
of
would just
those new entrants is thinking of taking jams in the competing directly against them, and they make a very credible case for it. Sorry, Amy, I didn't mean to cut across you.
Oh, no worries. I was just going to add on exactly. I'm 100% on board with everything that's been said, and add another piece that I think is often underappreciated but very important. We're starting to see institutional disruption. We're seeing disruption in the very legal regimes. In fact, the definition of the practice of law and what constitutes unauthorized practice of law is changing. And we're seeing a new sandbox mentality in the United States, for example, in both Utah and Arizona, that are welcoming these lower cost alternatives and embracing technology and what it might be able to empower smaller companies, empower economic development for these smaller businesses to be able to transact and resolve disputes all online, especially when we are talking about technology and technology disputes.
I completely agree. And I think especially Colin's description of an incumbent player, I think as arbitral institutions and arbitration lawyers, arbitrators, that's not language that I've heard thrown around that often to talk about the status quo. And I think it's a really important term, and I think it should help us think of the path forward in those terms, because maybe if we don't, we're just, taxi companies arguing about how to deliver a better taxi service, not seeing what was about to happen. So I think that terminology is very important for us to hang on to. Colin, next question for you is so Professor Ethan Katz, who is the director of the National Center for Technology and Dispute Resolution, has been quoted as saying, the power of technology to resolve disputes is dwarfed by its ability to generate disputes. And now some have called him the father of online dispute resolution, as I alluded to earlier. You've been called the godfather of online dispute resolution. Okay, so we're just repeating I'm just repeating what I heard others say. Can you comment on that quote and about how you see the ecosystem of disputes created by technology evolving going forward?
Sure, and I will never hesitate to sing the praises of Ethan, who is the true father. He named the field. He was doing this before it was a glimmer of any of our eyes. 2002 sounds early for my book, but Ethan wrote a book in 1985 talking about technology and the transformation of the law. So Ethan is the true father. And I want to thank Federico Ast from Claros for coining that Godfather phrase. I guess it's kind of stuck. And Myriam, I owe you dinner for continuing to.
And we'll get back to Claros for anyone who doesn't know what Colin is talking
Absolutely,
about.
absolutely. Talk about an innovative, disruptive new entrant in the space. I think that's great. But yeah, I was actually at the conference. I think it was an ABA dispute resolution section conference in Washington, D.C. when one of the presenters on a panel, Ethan and I were both in the audience. We didn't know each other that well at the time, but the presenter was talking about essentially a new technology, contractual elements. This is back in like 2000. And he said, we're never going to have any more disputes because, now that we have technology to confirm all these contractual arrangements, well, no one's ever going to disagree about anything. And Ethan stood up and said, respectfully, sir, the power of technology to resolve disputes is dwarfed by the power of technology to generate new disputes. And I think that's what I mean about the internet really revolutionizing commerce, is that, we used to buy and sell things in a certain way. We talked before about e-commerce, which started out, buyer to buyer, B2C and C2C, consumer to consumer. And a lot of the work that I did at eBay, these are very low dollar value disputes, high volume, low value cross-border cases. We had to build a system to resolve those kinds of cases. And I think a lot of people on the B2B level, $1 million and up in disputes and transactions, they were like, well, that's not really relevant to us. That's, mainly for people buying and selling things on Amazon. But I think the point that Ethan makes is very well taken in commerce, because now people buy cross-border very easily. I mean, it's as easy to buy. It's almost easier to buy something from another country than it is to buy from a domestic supplier. And I think that expansion of commercial opportunities has radically expanded the number of possible disputes and the complexity of those disputes, because you have people from different cultures, different legal regimes, different expectations around how transactions will occur. So the large internet intermediaries who are facilitating a lot of these transactions, they've been trying to put together dispute resolution mechanisms that can address these disputes as they arise. But, it's a losing battle. I mean, we've been trying to count, e-commerce is growing essentially 16% per year. And, we're talking about billions upon billions upon billions of disputes. And the volume of disputes that we're resolving in our dispute resolution.
I think Colin has frozen up.
Losing the race.
Oh, there we are.
Oh, did we have a hiccup? I'm sorry.
Yeah, you just.
We got losing the race though.
Oh, we got losing the race. Okay. All right. Sounds good. Well, again, the internet can generate disputes, one hiccup in the internet connection, and then you've got 500 disputes. So the point that I want to make is we need to be expanding our services as quickly as the source of those disputes are expanding. And that's e-commerce. The global technology e-commerce is changing radically. It's changing our society radically, and our institutions are not moving fast enough. So what we're seeing is a growing split between the dispute resolution approaches and society, which is, using technology to reinvent the way those disputes are occurring. So that's my 2 cents on the matter. I don't know, Amy, it looks like you have something to say on that too.
I think you're going to go to the next question. So I was.
Oh, okay. All right.
Well, the next question is for you, Amy. And I think that's a really good segue, because I wanted to talk about your book with Colin that you wrote together, called The New Handshake: Online Dispute Resolution and the Future of Consumer Protection. And your premise in that book, as I understand it anyway, is that consumer to business, so B2C relationships that originate online, so where the parties have never actually met in person, maybe in different countries, should have dispute resolution mechanisms that are also online. And you frame that premise in terms of access to justice. And I guess it sounds from Colin's comments just now that actually would have a lot of application to our topic today, which is commercial disputes that may be much larger than the B2C, being, it could be several million, maybe even tens of millions of dollars, perhaps not the billion-dollar claims that, as Sophie mentions, are unlikely to be, they're not the ones we think of in terms of needing more access to justice, but the very large ecosystem of disputes that are smaller than that, but still large in objective terms. Can you comment on how the theories from your book and your academic work in this area might apply to this type of dispute?
Yeah, I mean, quite honestly, even how I stumbled upon Colin and ODR long time ago, almost 20 years ago, was due to just problem solving. functional analysis, simple as that, looking at a problem. And the problem at the time, we were looking at B2C, and really avoid an access to justice, avoid an access to remedies. Essentially, we live in a society, and as Sophie appropriately talked about, due process, in the courts, you don't even get it, right? And so when it came to consumers, and even my own empirical research, it showed that individuals simply would give up, right? So you were more likely to do nothing than to go ahead and get a remedy. And in fact, the whole idea of the new handshake was going back to the old days where, you could get on your bike, ride your bike down to the farmer stand, shake the hand of the farmer who sold you the corn. And if the corn's bad, you can get new corn, right? Well, that's not how it works when all these transactions are happening online and there's no bike, there's no farm stand. You are all online, all anonymous. Frankly, you don't really know the individuals, but now small businesses are also transacting online in this exact same manner, right? And small businesses who don't know one another, who are not meeting face-to-face, it's simply too expensive. In the age of COVID, it's dangerous. And there's a lot of different reasons why you're not traveling anymore, right? And so you are setting up shop, you are setting up your farm stand essentially online, right? But you are a company and you're transacting in millions of dollars. And so $5 million now is a small, quote unquote, smallish claim, in the sense that it's still not going to be worth it to have to travel in order to resolve your dispute. And so what we're seeing is the same kind of problem solving or functional analysis that is laid out in the new handshake applied in B2B and small business transactions. And to Colin's point, I strongly echo, it's funny, you read all these different articles. I'm always reading and keeping up, especially in legal education. And there's all this sort of, the robots are coming for your job. We're not going to hire any more lawyers, don't go to law school. The truth of the matter is more disputes are erupting all the time, especially when it comes to technology and disputes that involve technology. And my advice to everyone out there is to get ahead of it, right? And as a student, to get ahead of it, to understand these disputes, to understand the different mechanisms that are out there, to understand smart contracts, blockchain, Claros, all these disruptors, because the truth of the matter is that's the wave of the future. And so that same functional analysis, going back to sort of your original question, the new handshake really does apply very appropriately. And in fact, I think it was like 2013, I was doing some research on economic development for developing nations. And the truth, developing these kind of mechanisms, really disruptive mechanisms for resolving and having amicable settlements with respect to technology disputes for these small companies from around the world on an international scale is tremendously helpful for everybody, right? And so I do think the new handshake fills a void. I do think these same sort of functional analysis apply to B2B as well as B2C.
Any other comments on that, Colin, Sophie?
Yeah, I do agree. I think the stereotype that online dispute resolution is more relevant to low dollar value e-commerce disputes, I think that's quickly going by the wayside. And I think we see these tools and techniques working their way up to higher value disputes. I put a link in the chat to APEC's new ODR system for cross-border B2B disputes. And I think, again, it's exactly on the case volume that you're targeting, Myriam, that $10 million to $100 million space. And I think the international arbitration systems were designed with the courts kind of in mind. I think we need to look to e-commerce for inspiration in terms of how these things can work. It's about scalability. It's about time to resolution. It's about consistency and efficacy. And I think that's why we're seeing innovation like Claros, which I think we're going to get back to.
We're creating such a sense of anticipation about Claros for anyone who's listening in and doesn't know what it is. So stay tuned for Claros. So the smaller qualifier in the title of the panel keeps getting larger, because now we're talking about up to $100 million as big, smaller. But that's a really good thing, because I think we deliberately chose that ambiguous language, because who knows what smaller means, right? It depends on context. The way I think of it is something that may be uneconomic to pursue in the systems that currently exist. That's the way I think of smaller, something at the low range. And certainly in my career, I've had to deliver a lot of, not so great news to a lot of clients about the uneconomic nature of a claim that they otherwise would have wanted to pursue, as I'm sure you've come across in your respective careers as well. So Sophie, turn it back to you. Do you, given what I've just said, given that certain small claims, perhaps based on the way things are currently being done by the incumbent players, if we're sticking with that terminology, do you think that there's an untapped market of claims out there that are not currently being pursued at all, and that tech tools could make possible to pursue?
There surely is a huge untapped market of not only smaller claims, but sometimes claims that are too time consuming to pursue. I also wonder about the broader societal phenomenon of immediacy of result and feedback. When we interact online, we are used to having an immediate reaction. To take a very basic example, most of us, some maybe enlightened beings have resisted this, but most of us are addicted to peers liking or reacting to something that we post online, be it on LinkedIn or on more social media, such as Instagram. And quite pervasively, I would argue that this translates into a lot of our attitudes in life. Peer validation has become extremely important. And there's not a huge step to take in thinking that the reaction of peers to a dispute that you might have is going to very quickly become as valuable, if not more valuable, than the decision of 3 arbitrators or a single arbitrators chosen by an institution. And I do wonder, this is maybe a more physical question, philosophical question of the tech impact on this industry, but I really think that the approach to disputes, I mean, not only is there a huge untapped market, but the approach to any disputes is going to change radically just because of the presence of technology in our lives.
Back to disruption.
Mm-hmm.
Yeah. Amy, I think that there's a question in the Q&A from Celia Kayubi. I hope I'm pronouncing your name correctly, Celia. Apologies if I'm not. So I think she's going back to your reference, Amy, to the international, perhaps the developing country example that you gave. So the question is about ODR and B2B international conflict. Could you give any example about any case or initiative? So perhaps, yeah.
So first of all, yeah, and this goes back to sort of a question we haven't really talked about yet, which is really legal design and how you design the different processes to be user-friendly. And when you are talking about establishing any kind of a dispute resolution mechanism globally available, you do have to make sure, along with the title of this panel, that there's an app for that. In other words, it needs to be mobile-friendly, a mobile-friendly platform. I think the example actually that Colin put in the chat with APEC is a good one, because it's going to have global reach. And maybe, I don't know if we have time for this, it would be really great. I don't know, Sophie, did we want Colin to do any sort of a demo of that process, or did we want to include that in this portion or not? Or I did just put you on the spot, sorry.
No,
let's ask Colin.
I'm more than happy to do that. Actually, I think that since we only have an hour together, I'm happy to just refer to a couple websites that people can explore. I'll put in the chat also odr.info, which has a list of different platforms that people can check out. I'm more than happy to do that. Yeah, Myriam,
and
please.
What we could do is we could, depending on people's time, we could leave it to the end, and if anyone needs to drop off, they can drop off, of course.
That's a great
and then
idea.
We can gauge
Perfect.
time that way.
Well,
Perfect.
The important point, though, I do want to raise, which often comes up, which is, wait a minute, people don't have which is very true, home internet. So if you look at the statistics, you look at the empirical research, in fact, most individuals do use a mobile device. And so whatever you are creating for these new developments really, and if we talk about the incumbent players again, incumbent players generally don't have the same sort of mobile friendly platforms. And so I do think that becomes important when we think about disrupting in this space, is having mobile friendly arbitration available.
Absolutely.
You know, one of the points that Amy made before that I wanted to make sure we didn't lose, I think a lot of people, I talked to lots of bar associations and lawyer groups. I just did a course this past weekend on ODR at a law school. And the immediate reaction is, my job's going to go away. You know, I'd see EHUB just posted a great article about AI and arbitration, you know, and there's talk about, well, machine learning, Richard Susskind's written about this. Oh, the algorithms are going to come and they're going to displace us. And what are we going to do then? And I think the point that I want to make, and Amy said this as well, is I believe there are going to be more people working in international arbitration in 20 years than there are today. But the jobs are going to change very significantly. And if you look at what's happened in medicine, if you look at what's happened in finance, technology has eliminated many jobs in those spaces, but it's created far more. And what we're going to need to do is design systems that can deliver fast and fair resolutions to these kinds of cross-border SMB cases in a scalable way. And I think what that means is there's going to be many new jobs. We're going to rely on agents to negotiate settlements. We're going to rely on algorithms to evaluate the strength of our case. We're going to rely on algorithms to decide cases potentially. But it might be that there are arbitrators that are using third-party technology tools to advise their activities. We're going to rely on crowdsourced platforms like Sophie was talking about, where we may have peers that are evaluating our cases, where we create a marketplace where if we want a resolution out of the system, we have to deliver an evaluative outcome in another case. So again, we just need to be very creative in thinking about where all of this is going. The good news is other industries have already sketched out a map for how these transformations will take place. But I think it's very important that we embrace this innovation and create more of an entrepreneurial culture. You know, we talked about Clayton Christensen and disruptive innovation, but we also should talk about creative destruction, which means we need to create many, many experiments. And most of them are going to fail, but some of them are going to succeed. And it's those that are going to move the ball forward. So it's a wonderful thing to let 1,000 flowers bloom and see all this innovation that's occurring. And that's what we're going to do at the end. We'll show Claros, we'll show Jor, we'll show New Era ADR, we'll show Fair Claims, we'll show Adjudicate. All of these companies are experimenting with new models, and that's great. And most of them are going to fail. That's what's happened in the ODR space. But every time the dinosaur dies, the green shoots arise from the bones, and we learn from every one of these experiments. And that's the way Silicon Valley works. It's not, you know, you create Facebook and you become a billionaire. There are 1,000 other competitors to Facebook that didn't make it and they died, and Facebook is the winner. So we always focus on the winners, but it's this cauldron of creativity and entrepreneurialism. That's really what generates the forward progress, and we should embrace that, not resist it.
Yeah, I just want to quickly add to that 100%, just definitely agreeing with that. But I also just want to add real quickly to those out there. You know, if you go to odr.info and you check out the provider chart, but you can also go to SSRN. I've also done my own sort of analysis of these different providers. And what I think is surprising often is how many of these experiments are happening right now throughout the world. That chart is huge and it's growing, and there's more that aren't even listed in that chart that were just created yesterday, right? And so these laboratories are absolutely happening throughout the world with different experiments that are not the incumbent players, but these are all different experiments. And so check that out on odr.info, as well as the charts on SSRN, because I think it's really eye-opening if you are looking for examples.
So now we have the incumbent players and we have the new players. So it's good we have new labels that we can use to facilitate the discussion. Colin, can you tell us? So we've just heard a number of names, and we may be able to look at some of them shortly. But I guess there's a common perception, and I confess to have been part of the people that had such perception, that arbitration or you doing a virtual arbitration is just basically doing what we're doing right now, which is arbitrate over Zoom and what many people have become used to throughout the pandemic. And I guess it's a positive thing that people have become used to certain aspects of doing things virtually. But I don't think that's exactly what you're talking about when you say online arbitration. So can you give some examples, and not we'll get to the actual demos later on, but just what's involved that is different or additional to simply arbitration over Zoom?
Sure. Well, in ODR, I think we refer to Zoom as the gateway drug. I met many arbitrators prior to the pandemic who essentially said, no, you cannot do this online. It has to be face to face. It's the only way that it works. And, you have to read the body language and you have to be in the same room. And then, of course, the pandemic hit. That was no longer an option to get together face to face. And suddenly people started experimenting with video-based platforms. And now you see all the major arbitral institutions have issued documents saying, here's how we do online arbitration. You see reports coming out of organizations like JAMS and the ICC, the HKIAC, that indicate that these video proceedings are as effective, if not even more effective. And I think once who knows where we're going to get to a post-pandemic world. I don't think we're ever going to go dial it back to where we were 2 years ago. But I think if we can ever get the pandemic under control, I still believe that 50% of procedures are going to be online, just because people have gotten used to the convenience of it. And there are just cost benefits, there's time benefits. Now there's green benefits of not flying people all over the world. Now, if you've got $1 billion case, sure. There's plenty of money to fly around lawyers and arbitrators to, resolve that case, because you have so much money in question. And as you mentioned, I think for the really high dollar value cases, I think change will come slowest. But particularly, as Sophie mentions, for this unaddressed layer of lower dollar value cases, I think online technology opens up possibilities in terms of efficiency. Now, when we first started the ODR field, we just replicated offline dispute resolution online. And I think video, it's easy for people to wrap their heads around it, because, well, it's the same thing as if we're sitting in a conference room. We're just looking at each other in our little Brady Bunch grid. So it's essentially the same thing. There are questions we have to address in terms of, how do we know someone isn't being coached? And, there's other issues. And there's been a lot of talk amongst arbitrators about how do we deal with some of those challenges that emerge online. But what we realized very quickly, even in the early aughts, is that technology creates new possibilities, things that are just not feasible in a face-to-face process, and not even impractical, but sometimes impossible. And when we talk about some of these crowdsourced models, I mean, you're not going to be able to get 50 arbitrators to hear a case in person, if that case is worth $5 million. It's never going to happen. And much less 100 arbitrators or 500 arbitrators, expert arbitrators from all over the world. It's completely impractical to think you'd be able to do that. But online, it's a possibility. And some of these crowdsourced models, the scalability of it, if you create, what we call a European style documents only arbitration process, and you get a multi-arbitrator panel, you can do that online, and you can potentially wrap that case up in, a fraction of the time it would require if you were to do it face to face. So we're only beginning to learn about all of the possibilities that technology brings. And Amy mentioned some of them: blockchain, smart contracts, AI, machine learning, crowdsourcing. These are new things that have not traditionally been part of the international arbitration community, and everyone's experimenting with them. And as someone who's been lucky enough to advise some of these companies and play with some of these tools, they actually work. And, they can work at scale, and they can deliver fair resolutions that, in a sense, may be more trustworthy over the long term than the old model we have of 3 or 5 arbitrators, listening to proceedings in person. So, who knows what's coming? Maybe someone at Google is going to invent a baseball cap that can read your thoughts, and we can communicate telepathically. Well, then we'll build that into arbitration. But
I thought we agreed that we would not terrify people on this panel, Colin.
Well, terrify, for a nerd, this is all exciting. It's like, wow, sci-fi is coming true. But, whatever you can dream today, I guarantee there's some nerd here in Silicon Valley trying to make it a reality. So
no doubt. Okay, if we can shift, that's all very helpful. I'm sure we can unpack all of that in a lot more detail in a bit, but I just want to shift back for a second to international instruments that may have facilitated all of this, and send it back to you, Amy. So both you and Colin, you've obviously collaborated quite a lot in the past and ongoing. But you both participated in UNCITRAL Working Group 3's work on online dispute resolution for cross-border electronic commerce transactions. But that work ended in 2016, unfortunately, without any consensus. Could you speak briefly about what the group was trying to accomplish, what the main roadblocks were, and whether you think there's any prospect of rekindling those discussions?
Yeah, so I mean, that's a lot to, so I'll try to give it sort of in the nutshell version, as we say. So essentially, I think, you know, many of us were pretty excited, thinking this is going to work. There was a lot of excitement around creating a global online dispute resolution process that would then work in e-commerce throughout the world, right? And so there was a lot of interest in this really helping, again, economic development as well, and making people really feel comfortable making purchases cross-border, knowing that there was some sort of mechanism for getting a remedy if the purchase went awry. And so that was kind of at the base. And in fact, when it was first discussed, there was B2B and B2C. So it was not necessarily limited to consumers in the beginning when we first discussing this. And then it kind of became more about B2C. And we kind of developed started discussing different possible procedural rules. But the big sticking factor at the end of the day, it came down to enforcement of pre-dispute arbitration agreements. Globally, there is a huge chasm. There's in the US, for example, in the United States, pre-dispute arbitration clauses are enforceable. Now, in most of the rest of the world, there are some others that also enforce pre-dispute, but it really, for the most part, is not enforceable in many other nations, including the European Union, where they do not, except in certain circumstances, perhaps with special notice. There are some sort of different ways that this is discussed in the law and in the regulations, as well as the case law throughout the world. But in a nutshell, kind of an easy way to look at it is, for the most part, pre-dispute arbitration clauses are not enforceable in these consumer transactions in other parts of the world, whereas they are in the US. So this became a very hot button issue and really political. So I think that was one of the sticking points. In hindsight, I think another sticking point is exactly what we're talking about, which is how disruptive and how quickly private industry works. All of us who've ever worked with a public institution can attest that public institutions don't move as quickly as private industry. Private industry is out there innovating, out there doing exciting things, trying things out. It takes more time and it's more difficult to bring on new ideas in the public sphere. And I think that's another real issue that was kind of rumbling throughout the UNCITRAL Working Group 3, because there's a lot of this notion of, well, this is how we always do it. And this is what quote unquote due process includes. You know, I also love when Sophie said earlier, you know, due process shouldn't mean it takes a long time, right? But there is this notion in public institutions that we need to like jump through all of these hurdles all the time for every kind of dispute. The problem with that is sometimes you're establishing a regime where you are not fitting the form to the fuss. So one of the things we do talk about in system design, as Colin mentioned earlier, which I think is tremendously important for future jobs, is you need to create a forum, you need to create a process that fits the fuss, quote unquote. And so it needs to look at the context, the parties. And I think there was a little bit too much of this top down with UNCITRAL Working Group 3 and less of the bottom up that allows for innovation. And even though they said they wanted to allow for that innovation in private industry, I think there were some hurdles there. And like I said, pre-dispute arbitration was also a big hurdle. The other part of your question was the future. You know, I do think APEC, a lot of the individuals who are involved in UNCITRAL Working Group 3 shifted their focus to APEC. And I think we're seeing these kind of smaller regional dispute resolution processes perk up and percolate. And I think it allows for a bit, perhaps, being more of a sandbox, more of a regulatory, allowing for a little bit more innovation. I also see in particular industries, I had somebody call me this past summer about UNCITRAL Working Group 3, and there is interest, for example, in creating an international mechanism for resolving tourism disputes. And so we might see more contextual, more kind of focused processes, which quite frankly goes along with fitting the form to the fuss, right? Looking at the type of problem and then seeking a way to solve that particular problem using all these cool new tools that are now at our disposal.
Sophie, what do you say as an arbitrator about how do you fit the forum to the fuss, to quote Amy, and your earlier points about due process? Because I certainly, as an arbitration lawyer, I certainly agree that the costs, a very large portion of the costs involved, is kind of in, you know, meeting the certain due process or the procedures as we've come to know them, and as those of us who practice international arbitration are very used to, and may give up kicking and screaming. But what in your view are some of the ways that due process could be adjusted in order to make some of these smaller technology disputes more economic to resolve?
I mean, to be fair to us, the reason why we are wedded to the due process that we know is because there are courts overseeing and enforcing who have this notion of due process. I mean, if we move, and we will talk about this a bit later, but if we move to blockchain arbitration where the enforcement is automatic online, we won't have to worry about that. But as long as there is off-chain or in the real world enforcement, we have to worry about due process. Now, putting that aside, there is something that really strikes me in this. I'm about to publish on this, and this is something that really animates us on in the discussion on ArbTech. And it is that the notion of what constitutes fairness is changing because of the advent of technology. And by this, I mean the following. What users of dispute resolution used to think as fairness, which is having your day in court, putting your case as fully as you can, you know, essentially every single point, making sure that it's out there. That is slowly being replaced in the online world by not trust in fairness, but confidence in the technology and the fact that it will deliver results. And it's an imperceptible switch, but it is very real. And if you look at that switch as being a phenomenon that happens, then that's what I mean by saying our whole notions of what constitutes fairness and due process is changing. And that's what we're trying to convey to the developers, the entrepreneurs, the startups that are on ArbTech. And they are trying to tell us, look, guys, the way that you used to think of fairness as lawyers, it's actually evolving now. Now, what we value in the dispute resolution process is immediacy of result, and obviously an opportunity to have a dispute no longer bother us. It's no longer hanging, it's behind us, it's settled, and we trust the result of that. Now, what tools are available? I would say, and that may be controversial and I may change my mind yet, but as the technology is at the moment, I would say that the degree of human oversight is still important. It's important psychologically. It's not foolproof, but I think it allows a partnership with technology that optimizes dispute resolution as we know it. It may well be that in 2 years' time, when we have this panel on Paris Arbitration Week 2024 or whatever, I will say, you know what, the technology has evolved so much that I think those machines are, you know, more trustworthy than human judgment. I wouldn't say that now. I would say, and as has been put in the, I think the Q&A or the chat, the question of bias of algorithms is a real one. And heaven knows that humans are not free of bias either. But I think by sort of keeping a check on things, a human check on technology, and by using technology to sort of try to optimize what humans don't do very well, which is, you know, sift through a lot of information in an accurate and fast way, I think we can have a much, much better process.
So we've already talked about Claro several times, so let's go there right now. For those of you who've been waiting in anticipation, so I didn't know what it was up until a week and a half, 2 weeks ago, but I became very curious about it in preparing for this. And it's a blockchain-based dispute resolution system that runs on top of the Ethereum blockchain and describes itself as the Justice Protocol. So I wanted to try it. To do that, I opened a MetaMask wallet. I bought some Ether through it, And after arguing with my bank's security department to get them to process the cryptocurrency transaction, I finally was able to purchase the Ether. I converted the Ether to PNK tokens on Uniswap. I paid high gas fees in the process. I staked my PNK tokens in the Claros court to put myself forward as a juror to decide disputes on the Claros platform. And now I'm waiting to see whether I'll be drawn. This is a sentence that I barely understand right now, and I certainly would not have understood.
Myriam, such nerd props. I'm so impressed.
I had to try it, but that's what I had to do. So, Colin, can you translate what I just said, please?
Sure.
For those tuning in who may not be familiar with blockchain arbitration, and then comment on, give us your thoughts about what blockchain arbitration is going to accomplish and where it's going.
Sure. Well, I'm very impressed, Myriam, that you did all that in such a short period of time. Well done, navigating the world of virtual currencies. But yes, so essentially, the blockchain was a mechanism that was created as part of one of the earliest virtual currencies, Bitcoin. And I think in the decentralized finance space, the reason why the blockchain was necessary, it's sort of a core trust architecture. So when you put something into the blockchain, it means it's unalterable, which is a very valuable thing on the internet, because you don't know what's true and what's not. So if you can create a record of things and put them on this global distributed ledger, that can be incredibly valuable. Now, what you did to participate in Claros, essentially Claros is like a giant online jury. And people can sign up to participate as jurors. And what they do is they buy a little bit of a virtual currency, the Claros, as you mentioned, PNK, to stake themselves as a juror. And actually, Claros is quite simple in the way that it's designed. When you are a juror and you have a little bit of this virtual currency, if you are assigned a case where two disputants come in and they put their case in front of the Claros crowdsourced jury, you stake your participation as a juror with a little bit of your PNK, this virtual currency that you've purchased. And when you render a decision in an individual dispute, the question is, are you in the majority? Do you agree with the majority of the other jurors about the right outcome in that case? And if you are in the majority, you are rewarded with a little more PNK. You get a little bit of a financial reward. Now, if it turns out you're in the minority of the jury, you disagree with the majority of the other people, you actually lose a little bit of your PNK. And Federico asked, who put together the Claros, but it's a whole network of people that he's partnering with. He's done a lot of studies to determine, does this create appropriate incentives on a game theoretical basis for the jurors who are participating? And does it deliver quality outcomes in terms of resolving disputes fairly? And again, you're not talking about one arbitrator or two jurors or three jurors. You start out with a relatively small jury. If the participants in the dispute aren't happy with the outcome, they can request a sort of a retrial, in essence, a rehearing, and then your jury expands. And then if they don't like that, they can request another one, and then the jury expands further. So the system is designed in such a way that it's trustworthy on the part of the disputants who are bringing cases into Claros. Most of the cases that Claros is dealing with now are virtual currency related, because this community really understands this world well, and they need resolutions for some of the transactions that are occurring they need a decentralized resolution process to match their decentralized financial process in virtual currencies. But there's no limitation on the ability of this mechanism to tackle other kinds of disputes as people it gets more legitimacy. But essentially, you can think about it as a giant crowdsourced jury where the jurors are a little bit financially incentivized to perform well. And it's designed just like Bitcoin, just like Ethereum, just like Litecoin, all these virtual currencies. It's not corruptible from the outside. The system is administered on this third-party basis. Well, yeah, okay, Sophie's shaking her head. And there's some question about whether or not blockchains truly are incorruptible. As we start to study this more and more, that may be something we have to work harder over time, is to ensure that these systems, you can imagine if you had 1,000 jurors in your case, it's pretty hard to corrupt 1,000 jurors. Even more than 100 of them, it would be a challenge. So the kind of credibility that you get in a jury-based system is different than the kind of credibility you get when you go to the ICC and you get world-class arbitrators who have impeccable reputations like Sophie, who always deliver neutral, impartial, thoughtful deliberations on their cases. But that's essentially the way the Claros crowdsourced approach works. Correct me if I got anything wrong, Sophie. Federico isn't here, so if I got something ruefully wrong, I guess I'll have to buy him a beer.
No. You obviously you got it absolutely right, and Federico, I think, would, as always, he does applaud you. I was shaking my head, not because what you're saying is wrong, and the model on a game theory basis, which is essentially you gamble that the majority is going to go a certain way. And it's true that it is organized so as to minimize ability to corrupt. The problem in practice is, of course, that those jurors are all on Telegram, speaking to each other and seeking to influence each other in the back room under aliases, and so the whole game theory basis of Claros is eroded, in my view. I mean, obviously, I'm not an expert in game theory, but my understanding of it is that the whole point of it is that you have no clue what the others are going to decide. And so if you are going to try to influence decision in the back rooms of Telegram, then that corruption can creep in. Now, at the moment, as you say, very rightly say, Colin, this is first of all, there haven't been that many decisions. There's been like 500 or 600 maybe. They are decisions to do with a very, very esoteric ecosystem that is the crypto ecosystem, where people sort of all completely unregulated, people trust each other, it works. How you scale that up to mainstream though, with that difficulty, and how you scale up to mainstream a system that is essentially monetizes the delivery of justice in sort of rewarding consensus decisions is something that maybe as a society might create some tension points, just culturally speaking. That's a matter for evolution. So that's why I was a little bit shaking my head, not because of what you said at all.
I'm so relieved that I now have the topic for Paris Arbitration Week panel 2025, corruption of blockchain arbitrators.
It's already squared away. Sign it up.
Right,
Put
right.
it on the agenda.
Well, and this is fun. You know, I know just to weigh in, yeah, I started researching and looking at sort of Claros and blockchain arbitration quite a bit ago. It's been a long, yeah. In fact, so they were first sort of putting together Claros, I actually sat down in Montreal, bought a cup of coffee for the CTO and just wanted to see, how does this work? And we literally sat there in a coffee shop and talked about the math, talked about crypto economics and how it works, and game theory and the research that had been done. And I do think there's some really exciting and interesting work happening and how it actually works. And as Sophie said, I mean, if you trust the math and you're someone who you have been part of this crypto economic view for a long time and you're within this, I do think it makes a lot of sense. I do think, however, from sort of an academic standpoint, an interesting thread that maybe we need to explore further is how repeat player advantages come into play. So we all know, many know about repeat players and Mark Galanter's groundbreaking work in that area. And in arbitration, certainly repeat players has been a real theme in discussing incumbent arbitration institutions. However, you do have these same sort of repeat player advantages, you know, if you are talking to your fellow jurors, if there are these sort of corrupting mechanisms available because you know the rules of the game, you know how to play the game, you can game the game, right? So now game theory does not work in the same way it was meant to work. And so I do think these are really interesting threads that we need to dive more deeply and really expand on. The other question that Sophie raised that comes into play, which I think is very important, is our notion of quote unquote justice, or what we want from a process. And this becomes tremendously important when we talk about blockchain arbitration as well, because there's this question of what do you trust and who do you trust? And again, in the fuss, if the fuss is about whether, for example, a particular token should be on a particular exchange, definitely the forum fits the fuss. Why not use that forum because you're comfortable with the theory, you're comfortable using tokens, you're comfortable with the process, and it makes sense because you trust the math, right? And so this is the right process for your dispute. Now, how do you scale that to I don't know, buying and selling particular software off chain, right? So you're not talking about individuals that are already deeply entrenched in smart contracts, but you're talking about individuals that may not be. They may be like you were feeling, Sophie, and I mean, like you were feeling, Myriam, and going to buy tokens and paying gas fees and telling your bank that, no, this isn't a fraud, it's okay. So I do think these are going to be, they're real issues, right? We talk a lot. This is a whole nother panel, is how do you bring off-chain transactions on-chain for dispute resolution? I think that in and of itself is a tremendously important question to ask.
We have so many ideas for so many more panels, but for now we're actually out of time. So of course, anyone who needs to log off, absolutely, you're of course free to do so. Anyone who would like to stay on, I think Colin, if you're able to demonstrate some of the tools, that would be great. But before we do that, can I get each of you, I always ask panelists at the end to give us a call to action, a 30-second call to action. If you can just make one recommendation for what you would like people to take away today, what would that be? Sophie, do you want to start?
I would say for younger practitioners who want to break, I get asked this all the time, how do I become an arbitrator? How do I get my first case? Well, those cases, Kleros is one platform, there are others. JUR, for example, is in the process of starting a roster of arbitrators, and there are 3 tiers. One of these tiers is a beginner arbitrator. Great opportunity for those younger colleagues who want to get involved.
Perfect, thank you. Amy?
My piece of well, yeah, because I do know some students are listening in, and my biggest action item, again, focusing on younger individuals who are just breaking in and thinking about their futures, learn about all these different technologies.
If I could do it, you could.
Learn about the technologies. Yeah, get out ahead of it. Be that person, on the job. You know something that the other attorneys or the other institution don't know. Learning these new ideas, getting out ahead of it, understanding what works, what doesn't work, how do you attack an algorithm? Learning these things, I think, will make you incredibly valuable in the marketplace.
Wonderful, thank you, Amy. Colin?
I think I'm going to echo the same sentiment, maybe push it a little bit further too. My grandfather always used to say to me, don't build your business where the highway is, build your business where the highway is going. And I think one of the things that I would say is we need more entrepreneurialism in arbitration. We need people to think about where the field needs to go, and not necessarily in an incremental way. I think that being able to think outside the box, being able to think in a radical way about new approaches, I think that's the kind of innovation we need. And I think there's only so much you can do working within the system to evolve it in the right direction. Maybe if we think, as Sophie said, how far would Uber have gotten if they were selling to the taxi associations? How far would Airbnb have gotten if they were selling to Hilton and Hyatt? We need to think about, let's build a new system that works better and refine it over time. And that's going to be the truly disruptive, revolutionary change that may expand access to justice and take all of this to the next level. So I would urge everybody on this call, don't be afraid of it. Embrace it, and let's go see what we can do in terms of expanding the field.
And come on, Artec, we talk about it. It's not scary.
Arbitrate.com too, we'll put in
it. We're not scary.
Yeah, exactly.
This is not the end of the conversation about moving fast and breaking things. There are, right. I hope that everyone can there are truly a very large number of links to a very large number of articles circulating in the chat. So hopefully people who are interested can copy those. I will save it. So anyone who is interested but wasn't able to get it, contact me and I will give you the links. I will save the chat. This is all wonderful advice. Thank you to all of you. Colin, you have the floor to do demos of whatever you'd like to demo.
I'll just do a couple very quick things. Can you give me the ability to share screens real quick? Okay, that works. Let me just call out a couple sites that I'd like for people to check out. Someone said in the chat, are there competitors to Kleros? And I do want to point out, Kleros is an amazing service, very innovative. I also really want to call out Jur. I think Sophie might have mentioned them too. I think Alessandro and Jur, they definitely have the crowdsourced approach, but they also are bringing in sort of the expert arbitrator side and building a panel. 3 companies in the United States that I think are doing really interesting work. One is called Fair Claims, that's focused on these SMB size disputes. Stephen is doing a great job. Another one is called eJudicate. And these are all arbitration service providers. Again, there's a lot that's happening on crowdsourced and the mediation side. Another one that I've got my eye on is in Chicago, New Era ADR. That's also providing of arbitral services. And I also want to affirm the work that my friends at AAA and JAMS are doing. You know, National Arbitration Forum has been ahead on using technology for a long time. And there are many arbitral institutions. I know we worked with Corsica in Cairo. They're looking at technology. I think the Stockholm Chamber is doing amazing things with technology. Again, a lot of what I think ICC and LCIA are doing is mainly on the case management side, more so than the crowdsourcing side.
But ERA was also, I think it was developed originally by in-house counsel as well.
Was it?
Yeah, that's my understanding. They were frustrated with legacy, so
sure. And that's an excellent point, Sophie. I actually don't think that the arbitral institutional side is going to drive these changes. I think it's going to be demand from counsel, because I think that, you know, business is now online. So they expect dispute resolution is also going to be online. It's going to be equivalently streamlined. One other site that I want to call out, and I could do this all day, but I had a great conversation with Olaf from Norway about his.
And you're
site,
on a first name
Eporoto.
basis with all of the operators of all of these sites, as we can tell.
Well, I don't know. I'm lucky enough to be trying to publicize them. And again, I myself, we're building ODR.com, and we're going to launch that next year. So stay tuned. We've got a lot of things that we're working on that side. But again, all of us.
In the chat.
Yeah, it's not so much about one provider winning. It's about the ecosystem of all of these innovations complementing each other. And Eporoto is amazing because they use decision science to evaluate cases. And that's really the crux of a lot of this is, you know, what is this case worth? What is a fair outcome for this case? And when he showed me his software for doing that, asking certain questions and then creating a evaluation of a dispute, this could be the heart. And we haven't really done much talking about some of the AI machine learning tools. A lot of those things are happening in the academic environment, but I've seen some experiments that are very impressive. But the other thing we mentioned before, the provider list at odr.info, the National Center for Technology and Dispute Resolution, you can see how many examples we have of some of these are crowdsourced, some of these are arbitral, some of these are human powered. There's a lot of really cool stuff here. And every time we find out about a new opportunity, we put it on this list.
Can you go back to the map? Is there a way to make the map
Sure.
larger?
This map here? Or the
map
fellows
showing where.
I'm sorry,
that the map of the fellows, not of the locations of the providers?
That's exactly right. You
Sorry,
can see
okay.
we have international fellows, many of whom are academics who are doing research
Understood.
in ODR. So that's what our map is of. It would be an interesting idea to do a provider list
because
with a map.
my point was going to be, if you see a lot in North America and Europe, but fewer in Asia, South America, Africa. So I know that we perhaps have a lot of people joining us from those regions, and so
Absolutely.
even I would say the call to action from me is even kind of everything that's already been said of younger practitioners, especially if you're in areas that are underserved by some of these tools. Be, you know, the trailblazer to develop them, because especially in many parts of the world where, you know, cost is maybe even more of a concern to make access to justice possible, these tools are especially relevant, I think. Particularly to take up Amy's point, the mobile phone use. I spent a lot of time in Latin America. Mobile phone use is very, very high. And you have people who have access to the internet through mobile phones that don't have access to the internet as much in other ways. And so I think that's very, very relevant especially if you're from those areas.
Absolutely.
To Myriam.
Please. Yeah.
Oh, I was
Amy.
just going to add how exciting. I mean, so I teach an ODR online LLM class with international students, and really, to be honest, my biggest joy has been the fact that many of these students go on to be entrepreneurs in their own countries. There's really cool things happening. I invite people to look at ODR Africa really cool things, Morinike, and also to Dema and some of the others that have been now, they were students and now they're out there, you know, really creating processes. And it's just really cool to see this happening worldwide.
Absolutely. As I said, we could click on websites all day and all night, but I think, Myriam, what you're identifying in the provider list may be an artifact of the fact that we speak English. So we come across those a little bit more easily. There is so much innovation happening in India. I feel like I'm hearing about a new ODR provider every month. The government is embracing ODR in places like Brazil and India and Singapore and China, even more aggressively than European and North American countries. So the innovation is happening, and this is great. This is what we need. And, you know, not everybody's going to succeed, but we're going to move the ball forward. Every experiment moves the ball forward. And I do think we need culturally appropriate services in each region. And that's why I'm happy to see Morinike doing ODR Africa. I'm happy to see Alberto doing ODR Latino America. We know about ODR experiments arising pretty much on every continent. Antarctica, I don't know, ODR Antarctica was not created yet, but soon enough. Yeah.
Sophia Munoz is asking for an example from Latin America, if you have one.
Yeah, I was just about to show this platform, eConciliador, which is actually in Brazil. This is a fascinating platform. And what they do is they resolve, again, it's not B2B at this point. It's mainly, I think, consumer to business disputes, but it's all agent-based. So if you have a dispute between a telecom company and an individual, that you can use this mechanism to create essentially algorithms on each side that will resolve the case. The consumer can negotiate against a mathematical model that was created by the telecom company and get fast resolution to these cases. So there's so much innovation that's happening in Brazil and Argentina and Peru and Chile right now. It's very exciting. And, you know, I had an opportunity to go to China and see some of their new ODR experiments. They look very different than what's happening in the United States. And that's all to the good. You know, we created the community court at eBay, which was the first scalable crowdsourced ODR mechanism. And we did tens of thousands of cases. And then Taobao in China, they took that same mechanism, built their own crowdsourced solution, and they've done millions of resolutions through that design. So, and I want to give credit to my friend Daniel Dimov, who wrote the first book on crowdsourced online dispute resolution. So the roots of this go back decades, but every time there's an experiment, it moves the ball forward. So I encourage you to explore and find some of the new mechanisms that are launching. I'm a big fan of the RDO platform, Resolve Disputes Online in the UK, and I work very closely with the CREC team in India, which is also a great ODR platform. So I'm gonna resist the temptation to just keep clicking on websites.
There are so many. Well, Victoria da Silveira, I think, has identified consumidor.gov.br, which would be a Brazilian one. And then Umang there from India, resolveoncord.com. So, okay, there are obviously so many of these platforms available.
That's right.
So that's really interesting. So the recording will be, I'm sure people didn't have time to take a note of all of these websites. So the recording will be available. And so you can scroll to the end and have a look at them, or just email me and I can help you find it. Wonderful. Okay. Well, thank you to all of you. This was extremely informative. Obviously, there's so much that can be discussed in this area, and I'm very grateful because I have my panel topics all lined up for the next conferences. So that's great. Thank you very much for your insights, and enjoy the rest of Paris Arbitration Week.
Thank you so much, everyone, and thank you, Myriam. You were a wonderful host.
Thank you so much.
Thank you, Myriam.
Have a good day, Colin. Good rest of your day, Amy. Good evening, Sophie. And good evening, or wherever you are.
Goodbye, everyone.
Goodbye.
Stay well.
Thank you.